start here. And it's my understanding this is being live streamed. So all those persons that were here earlier have the opportunity to view via live stream, which is something the county Maricopa County Superior Court has always encouraged. All right. Let me ask Mr. Blem, have we got service of process accomplished for all the participants?
Yes, Your Honor, and it's my understanding that the summons, the notice of service has been filed with respect to every defendant.
Okay, very good.
Your Honor, this is Alexis Daneman. This is Alexis Daneman. The secretary has not been served in her personal capacity, to our knowledge.
Next, responsive pleadings. Was there in terms of responsive pleadings, was there a motion to dismiss contemplated? Is there an answer going to be filed? Tell me from the defendant's perspective. I haven't seen anything in the docket, but I know this is moving fast.
Your Honor, this is Andy Gaona on behalf of Secretary Hobbs in her official capacity. The Secretary's office does plan to file a motion to dismiss. I believe that the governor-elect also intends to file a motion to dismiss as to all claims. And we would like to propose a schedule to the court, if you'd like to hear that now, in terms of how we foresee that proceeding expeditiously.
All right, go ahead and tell me what you think.
Your Honor, our proposal is that the defendants file motions to dismiss on no later than Thursday, the 15th at noon, that any responses from the plaintiff be filed on Saturday, the 17th at noon, and that any replies be filed on Sunday, the 18th by 5 p.m. with the goal, if the court schedule would allow it, of holding oral argument sometime on Monday, because the Secretary does believe that the court will be able to dispose of this case in its entirety on motions to dismiss without the need for an evidentiary hearing.
Okay. Does anybody else want to be heard about that time frame?
Your Honor, Thomas Lee for the Maricopa County Defendants. We can agree to abide by the schedule just presented to you by Mr. Gaona, and we also anticipate filing a motion to dismiss.
Okay.
The governor-elect also agrees with that schedule.
Okay. Mr. Blem?
Your Honor, I'm going to defer this question to co-counsel Kurt Olson, if I may.
And Your Honor, before Mr. Olson addresses the court, is he admitted pro hoc vice yet?
I haven't seen the request.
We're in the process of doing that, Your Honor.
Okay. All right, but so Mr. Blem, do you want to talk to me about what you think should be the schedule on the motion to dismiss? Mr. Blem, are you there? Mr. Blem, can you hear me?
I can hear you, Your Honor. I apologize. I, for some reason, left the room and then came back. I'm not sure what's going on.
Okay. Well, Mr. Olson has not been admitted yet. He is in the process of his pro hac vice application, but I was asking for your input with regard to that proposed schedule.
We are fine with that, Your Honor.
And in terms of an order, Your Honor, this is Andy Gaona again on behalf of Secretary Hobbs in her official capacity. We would just ask that your order reflect that all filings with respect to the motion to dismiss be served by email and Turbo Court, and of course we would provide courtesy copies to the court's judicial assistant at the same time.
Okay.
And plaintiff agrees with that, Your Honor. And really quickly, I would like to know what time their motion to dismiss will be done.
Well, Hold on a second.
And so I guess what I'm looking for here.
Proposal they've got is Thursday at noon to file. Saturday, the 17th for response. And when did you say the reply?
Your Honor, my proposal was Sunday, the 18th by 5 p.m. On the assumption that the court has room on its calendar on Monday for an oral argument and to provide the court enough time to read the fully briefed motions.
Okay, and what were you envisioning for oral argument time? I mean, how much time?
Your Honor, given that there will be 3 moving parties, I would imagine we'd probably need an hour.
An hour per each side.
An hour total, Your Honor.
Well, okay.
Your Honor, I think that's way inadequate.
Well, I was thinking at least an hour each side. I mean, if we've got three different parties speaking, the motions, okay, so that would be, and then what are you thinking about an actual hearing?
Well, really quickly, Your Honor, given there are going to be 3 moving parties, would anybody object to us doing a consolidated response?
Your Honor, Secretary Hobbs would have no objection to a consolidated response.
Your Honor, Maricopa County would have no objection.
The governor-elect would have no objection.
That sounds fair to me.
Thank you.
All right, what about, okay, so oral argument on the 19th is what you're proposing, and then in the event that we go past the motion to dismiss, setting a hearing when?
I would envision we would have a hearing. We've got to hold a trial in this matter within 10 days after service, Your Honor. So maybe Wednesday.
Okay, go ahead.
Tuesday afternoon, Wednesday or Tuesday afternoon, Your Honor. You need time to, of course, issue your orders.
Right. I was thinking Wednesday. Looking at the timing of this, this is a statutory creature, and I've tried to be very careful about looking at the times involved. So I have to leave myself a little bit of time, a reasonable amount of time, to rule to go through things. And so if we do the hearing Wednesday, how much time are we envisioning on that? Mr. Bunn?
Are you saying a hearing after the
Yes.
oral argument and your ruling has been issued?
Yes.
Well, if we're talking about a scheduling conference type of hearing, I would probably suggest we would need no more than a half hour to an hour.
No. I'm talking about if we need a hearing because of the ruling, I'm giving you some type of a guidance or leeway to understand in advance where we would be going next. So I'm looking at probably Wednesday.
All right, well, we would ask for a 3-day trial in that case, Your Honor, at least 3 days.
Okay. That would take us up to Christmas Eve, and then under the statute, I've got 5 days to rule at that point, and that takes us right up to basically the weekend of January 2nd. because the ruling isn't something that I'm going to be able to do in 15 minutes. This is going to take.
Understood, Your Honor.
So how much time you ask for trial cuts you off on the tail end. So I was envisioning something, but this is a hearing, not a full-blown trial. So I'm envisioning something like a total of 6 hours, 3 hours divided between the two of you, meaning two sides.
Well, this is a pretty significant factual hearing, Your Honor. It is in essence a trial on the issues that are presented by my client. And, you know, we think 3 days is more than sufficient time for us to have this trial, Your Honor. Absent that, definitely more than 6 hours and 3 hours per side.
Your Honor, may the defendants be heard on this issue?
Sure.
Your Honor, the Secretary would agree with the court's proposal for a one-day trial with 3 hours per side. This, as the court notes, pushing this back any further will threaten the orderly transition of power that is set to take place on January 2nd. And essentially a one-day hearing should give the plaintiffs the opportunity to make whatever case they believe they have, a case we believe is non-existent, that this election should be overturned, and they can make whatever arguments they need to at that point. Moreover, Your Honor, I would add that I do not believe that an evidentiary hearing is necessary, and it's our belief that the court will be dismissing this action after its consideration of the motions to dismiss.
We've done pretty well up to now with staying away from advocacy. We've basically tried to antiseptically analyze where we are. I'd like to stick with that analysis. If we're talking 3 days from the 21st to the 23rd, then the ruling could take us right up until the 11th hour. And I've got some serious concerns with that. And I understand that there is a volume of material that's been presented. Nevertheless, I think that it's probably more appropriate to lessen.
Your Honor, if I may, then I would ask this court to move the trial begin date up so that this court has ample time to hear the evidence that it needs to hear to make a decision. I would also offer, Your Honor, that this matter's going to go up regardless of which way it goes.
Your Honor, this is Thomas Liddy from Maricopa County. May I be heard on this?
Yes.
Your Honor, I've gone through as much of the evidence as it's been proposed as I can, and a great deal of it is duplicative. Another very large portion is of dubious probative value. And I think as we proceed this, Your Honor will not need 3 days to hear non-duplicative probative information in order to deal with the issues that are probably before this court. I think 1 day is more than enough for each side to present its argument to this court.
Okay.
And Your Honor, that's one defendant's view of the evidence. And so we want ample time to be able to present that evidence. And we don't believe 6 hours divided between all the parties, at least in this case, is ample time to do that. And I believe, Your Honor, the statute says the trial will be continued from day to day.
You're right. It does say that, but it also contemplates that I have the opportunity to have time for ruling, and that takes it up to 5 days. And if part of the problem is the volume of the evidence here. And so while I can read before the trial, read it afterwards, it's also the focus of the motion in limine or the motion to dismiss. I anticipate that the trial will be more along the lines of focusing on the most pertinent points to point out to the court with regard to the issues in 672 are fairly discrete. And so that would be the focus of the hearing. So I'm going to set the hearing for 2 days for December 21st and 22nd.
Thank you, Your Honor.
And the time would be evenly split between the parties in terms of the number of hours involved in that. All right, so.
Your Honor, this is Alexis.
I'm sorry?
Your Honor, this is Alexis Danneman. May I be heard on this issue?
Yes, ma'am.
I would say that the statute 16676A contemplate the court sets the time for the hearing of the contest not later than 10 days from the filing, which would be Monday. There's an ability for some additional time for good cause shown, but you know, I do not believe that that is the case here. We still have not been served in this case.
Mm-hmm. Correct. All right.
And you will have that acceptance of service form today. And if I may just inquire really quickly, Your Honor, this court is setting it for 2 days, which we do appreciate, and is divided time equally between the parties. Is that equally, all defendants get the exact same amount of time individually as does plaintiff?
Well, I can hear from them if they have a disagreement otherwise, but I think that their willingness on the motion to dismiss to file a unified response tells me that their positions are fairly uniform. If that's the case, I have no problem dividing the time equally between the two sides rather than just equally between parties.
We're doing our own motion.
Thank you, Your Honor.
So if we want to be heard, I will listen. Mr. Gaona?
I was just say, Your Honor, I think there was a slight, just a slight correction. I think that there will be 3 separate motions to dismiss, but Mr. Blem talked about a consolidated response that we had agreed on.
You're right. I understand. But do you agree with the characterization that the positions of the defendants are fairly unified in terms of the issues?
In terms of the issues, that's probably generally true, Your Honor, and I have no objection to the defendants collectively splitting that half of the time, okay, if that's the question.
Yes, it is. Yes, it is. Mr. Liddy?
Your Honor, for the Maricopa County, the Board of Supervisors, and Maricopa County Recorder, we would agree to split the time with other defendants.
All right.
Your Honor, for Maricopa County, I do have one other issue I need to raise before the court, and that is that there's a substantial number of exhibits associated with the declarant Shelby Bush that unlawfully publish signatures and other personal information in violation of Title 16, 168F. And I would move this court at this time to place those documents, those proposed exhibits, under seal.
Any objection by anybody?
We have no objection, Your Honor.
So,
we do have an objection to the characterization of how the evidence was obtained, though, Your Honor.
Your Honor, Maricopa County did not make any representations to how it was obtained, but I will tell you, I picked it up on a thumb drive this morning about, or my associate did at 8:40 this morning.
All right. I'm not going to go into that, but I think what you've done is helpfully pointed out that there may be voter information out there that we need to have sealed. And that does make sense to me that we go ahead and order that sealed. For the clerk's sake, that would be the affidavit of Shelby Bush. I don't know that we have a Bates or other identification system. Mr. Blem, can you help me out where that's at?
Yes, Your Honor. And I just want to add that all the documents produced and attached with the Shelby Bush affidavit have had all personal identifying information redacted from them. So there is no PII that we need to be concerned with in that matter with respect to Shelby Bush's declaration. And so in that regard, Your Honor, we prefer they not be sealed. And it's tab C, Your Honor.
It's pardon? I didn't catch the last thing.
Yeah, Shelby Bush's declaration is tab C, but we don't believe they need to be sealed because they're not PII, and they are excellent examples of just exactly how the county conducts elections in Maricopa.
Sealing it is not going to remove it from consideration by the parties or the court. It's going to seal it from public view. So I'm exercising an excess of caution to protect voter information. I mean, this is not the time for a hearing. I had an ex parte motion from you, Mr. Blem, where that was addressed. First thing on Monday morning, you were outside my chambers with a motion to deal with this. I'm just
Understood, Your Honor. Yep, that's because I had made a mistake and that I attached the wrong stack of documents. This court now is in possession, and thank you for entering that order. This court is now in possession of all the documents in a redacted form that do not disclose any PII relative to voters, Your Honor.
True, but it's in public records law. I cannot strike something. I can only seal it. And so sealing it is not going to do anything to destroy the information. It will just preserve the privacy. And I'll grant the request then. So we'll seal the affidavit of Shelby Bush and tab C pursuant to Shelby Bush and tab C pursuant to 16168F. So,
Your Honor, just to be clear, it's the exhibits that are associated with Shelby Bush's declaration. So all those, specifically the signatures of the voters that render them susceptible and vulnerable to voter ID theft, to ID theft.
What you're asking for is the affidavit plus the attachments.
Thank you, Your Honor. That's correct.
And Your Honor, if I just may one last time, there is no potential voter theft just because all the PII has been removed. And we think that these are exhibits the public needs to see. The public needs to be aware of how Maricopa County is conducting its elections, Your Honor, and that's our position.
Okay, well, that's part of the point of the hearings, but none of this has been briefed. And I have an oral motion simply to protect voter information, so I can either err on the side of caution and grant the request, or take your word for it, Mr. Blem, that there's no harm, no foul, and leave it out there. I'm going to err on the side of caution and protect the information so that the voter information is not disclosed. However, it is fully part of this case and can be used by the parties in their counsel. So my ruling is going to stay the same on that.
Thank you, Your Honor.
Okay.
Your Honor.
Yes.
Sorry to interrupt. Alexis Daneman, one point of clarification on the motion to dismiss briefing. That the plaintiff will file a consolidated response, but I just want to clarify that we will still intend to file 3 separate reply briefs.
Yes. So the schedule on the motions to dismiss, they will be filed by Thursday at noon. The unified response to all 3 motions, if there are 3 filed, will be due on Saturday, and that would be Saturday at noon. And then the replies would be separately due on Sunday by 5 p.m. I will tell you that, yes, and I agree that the documents may be served via email and Turbo Court. I'm going to caution everybody that with Turbo Court, we're doing our best to push things forward, but there's a lag time between things being filed and scanned in Turbo Court unless they're e-filed. the long story short is courtesy copies are very essential to move this case along timely and make sure that everybody has everything as quickly as possible, which is in this case. So that's the schedule for the motion to dismiss. Then for the 19th, I'll set oral argument on the motion to dismiss, and I'll set that for 9 o'clock in the morning, and that'll be for 2 hours with an hour on each side. And then the hearing, it's referred to in the statute as a hearing, so I'll set the 2-day hearing December 21st and 22nd, beginning at 9 a.m. to 4:30 p.m. on each of those 2 days, with the time being divided equally between the two sides. So have I left anything out?
I don't believe so, Your Honor.
Okay, I'm not hearing anything. So I thank you all for your participation today. Again, I apologize for the delay. If you would, I don't know how that link was so widely distributed, and I'm not going to go into it at this time with anybody speculating how that happened. But however it got distributed, if the word could be distributed to use the Maricopa County Superior Court live stream website link, that would be sincerely appreciated, because it is important for the public to have full view of this and access, but we cannot crowd the Teams platform such that the attorneys and their parties involved in this case aren't even able to participate. With that, I think I've covered everything I need to cover with you all, and I can excuse you and wish you a wonderful rest of your day. Thank you all.
Your Honor, if I may really quickly before we adjourn, the plaintiffs do intend to file a ARS 16677 motion 2 days for access to the ballots, or some of the ballots. And so we will courtesy copy that on all of the on counsel for all the parties.
Okay. Well, 16677 provides that once you've filed the verified petition stating you cannot properly prepare for trial without an inspection of the ballots, and the bond approved by the clerk with 2 sureties in the amount of $300, the court shall appoint 3 persons, 1 selected by each of the parties and 1 by the court, by whom the inspection would be made. So what I would like is if that is filed and the parties have nominations for those persons, or you can appoint the person, I believe it would be 1 per side, unless there's a reason to proceed otherwise. And then if you can give nominations for the person to be appointed by the court, that would be appreciated. And so we can.
Your Honor, I'm sorry to interrupt. I just wanted to ask if we can set a briefing schedule, because I imagine the secretary and I imagine some of the other defendants will want to object to that request. I think there is some good case law out there about how we do not allow parties to poke around ballots if they fail to state a claim, and that's the situation that we're going to find ourselves in here. So we would like an opportunity to respond in writing to whatever petition that Mr. Blem intends to file.
All right. How much time do you need to respond? It says the statute starts, subpart A says, after the statement of contest has been filed and the action is at issue. either party may have the ballots inspected before preparing for trial. So legally, when the actions at issue becomes operative.
And Your Honor, we don't intend to ask for, of course, all the ballots to inspect. It's going to be a limited inspection.
Well, I guess the way to go about it would be to file your statement and then your request, and then the other side can respond, and you can provide that timely. So,
will do,
Your Honor.
Yes, Mr.
Your Honor,
Liddy.
Thomas Liddy from Maricopa County and the Maricopa County Recorder. My clients are in possession of the ballots and have legal responsibilities to guard them as such. And so if there's only going to be only one person there from the defendant's side, I think that should either be from the Secretary of State or the governor-elect, but Maricopa County will necessarily have to be physically present to administer the viewing of the ballots and to, well, they're in our possession. We've got some responsibilities with regard to that, Your Honor.
That's understood by plaintiffs, and we don't object to that.
In fact, I'm not sure how that might work out with the court appointing somebody, but my concern is more appropriately maintaining the chain of custody or the sanctity of the ballots that we've got. So I'll let you go ahead and file your request, Mr. Blem, and then the defendants can file their response. We'll proceed accordingly.
Thank you, Your Honor.
All right. Then I believe that's all that we needed to cover today. So I'll excuse you all. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.